181. Case is style of State of Texas versus Luis Fabian Salazar.
He's present, Your Honor.
Salazar, would you please come forward? Ms. Jackson. Mr. Salazar, your full name is Luis Fabian Salazar?
Yes, sir.
How are you doing, Mr. Salazar? That's good. Mr. Salazar, you represented in your case by your attorney. Attorney James Macon. Attorney Macon, how are you doing?
Wonderful, Your Honor.
That's good. And the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge. How are you?
I'm doing fine. Thanks for asking. Mr. Macon, what is your announcement in Mr. Salazar's case?
Your Honor, I believe that this will result in a plea at some point. However, at this time, I do not have the tape. And I need that before I could go forward. We
Okay.
requested it the last time on February 19th.
Okay. State, well, how much time do you think?
30 days.
30 days? You'll be able to get it? You'll be able to get it to him in 30 days? Or give him access to it?
We should be able to.
Okay.
The requests already been put in with
Yeah.
the trial division. Okay.
Yeah, twice.
Give us a reset date. April 29th? Okay, April 29th is your reset date. Mr. Salazar, your attorney is going to get your reset. Once you get your reset from your attorney, you're free to go and you have a blessed day.
You too.
And you have a blessed day as well, Mr. Macon.
Thank you.
Yes. Next case is cause number 23CCCR 2470. Case is style of State of Texas versus Debbie Vaught. Ms. Vaught, would you please come forward? Ms. Vaught, your full name is Debbie Vaught.
Debbie Marie Bell.
How you doing, Ms. Vaught?
I'm okay.
That's good. Ms. Vaught, you're represented by your attorney, Attorney Reagan Monaldi. Attorney Monaldi, how are you doing?
I'm good. Thank you, Judge. How are you?
I'm doing fine. Thanks for asking. And the state is represented in this case by Attorney Erica Porter. Ms. Porter, how are you doing?
I'm good right now.
That's good. Now, Ms. Monaldi, what is your announcement in Ms. Vaught's case?
Yes, Judge, we just got this case. This is our first appearance on it. I think we are looking for a resetting. I'm talking with ABA Erica about offers or potential resolutions, but we just need some time to do that.
Okay. I'm looking in the file. Let's see if there's.
The state may change, but that's your no.
I don't think I have any, no. Give me some bond conditions. I need to give her some bond conditions. I noticed that we didn't have any bond conditions. Okay. Okay, Ms. Vaught, I have some bond conditions that I'm going to read to you. You'll be able to get a copy of these bond conditions once you leave here today.
Thank you.
You're welcome. And Ms. Vaught, the title of the document is Standard Bond Conditions and County Court at Law number 2. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, Your Honor.
The defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, Your Honor.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, Your Honor.
And condition number 4 does not apply because that only applies in a DWI case. Your case is not a DWI case. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, Your Honor.
Now, Ms. Vouts, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest, and you'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, Your Honor.
Okay. Your attorney is going to get a copy of your reset and a copy of these bond conditions. Once you get a copy of the reset and the bond conditions, you're free to go, and you have a blessed day. And Ms. Minaldi, you can stand in front of the court coordinator, and she'll give copies of the reset and the bond conditions.
Okay, thank you, Your Honor.
Okay. What's that reset date?
It's gonna be April 26th.
April 26th? Okay. Next case is cause number 23CCCR 1378. Case is style, the state of Texas versus Korea Gidry.
Actually, has 3 cases, Judge.
Okay. And cause number M332530 and cause number M333068. All 3 cases are style, the state of Texas versus Korea Gidry. Is your first name pronounced Korea?
Kiara.
Kiara? Okay, so it's Kiara Justina Gidry? Okay, how you doing, Ms. Gidry?
Fine.
I'm doing fine, thanks for asking. Ms. Gidry, you're represented in your cases by your attorney, Attorney Charles Rojas. Attorney Rojas, how are you doing?
Doing well, Judge. Thank you.
That's good. Now, Mr. Rojas, what is your announcement in Ms. Gidry's cases?
Judge, we have offers in each of Ms. Gidry's case. She wants to reject those offers and set it on trial document.
You gonna reset it for trial?
Yes, sir.
Okay. Give us a trial date.
April 8th.
Okay, Ms. Gidry, these cases will be reset for trial on April 8th of 2024. Your attorney is going to be given a reset. Once you get your reset from your attorney, you'll be free to go, and you have a blessed day. Just please stand in front of the court coordinator. She has another one. Mark Love. Mark Love,
He's outside, Judge. I think we may be able to work it out.
okay. Okay, I'll hold on it. Next 2 cases, defer to judicial. that's something else. Okay, judicial review. Got a judicial review at 9:30. Yeah, I have three non-disclosures, yeah. What time are they scheduled? Okay, it's 10:30, 11, okay. Okay, that's a judicial review. I don't think the, Mr. Gillen is the probation officer here for the judicial review. Who's doing that? Will you be doing that?
I certainly can review that, yes.
Oh, you can't. Who you sent it to? Nathaniel Allen?
Oh, that's.
Is it- Just hold on, Mr. Oh, that must be the probation officer right there.
Yeah, they don't.
Okay,
I'm looking on November.
You ready right now?
well, let's see if the prosecutor is ready. You
Your Honor, I was mistaken. I was.
thinking about another case? That's a judicial review. You need some time to talk to the probation officer about that? Okay. He's on there. This is cause number 23 CCCR 0310, case of style of state of Texas versus Robert A. Villanueva. Mr. Villanueva is on Zoom. Mr. Villanueva, you can take your mic off of mute.
Yes, Your Honor.
Mr. Villanueva, how are you doing?
I'm doing good. You?
I'm doing fine. Thanks for asking. Mr. Villanueva, you're represented in your case by your attorney, Attorney Ralph Kimler. Attorney
Yes,
Kimler, how,
Well, thank you, Your Honor.
Mr. Kimler, what is your announcement in Mr. Villanueva's case?
Trial.
Okay, reset it for trial. Okay, this case will be reset for trial on April the 8th of 2024. Your attorney, Mr. Kimler, and your bondsman will be given notice of your reset date of April 8th, 2024. Stay in contact with your attorney and your bondsman. You're free to go. You have a blessed day.
Yes, sir. Thank you.
You're welcome. Okay. Next case is cause number M327829. Case is style of state of Texas versus Nathaniel Allen. This is cause number M327829. Case is style of state of Texas versus Nathaniel Allen. Mr. Allen, is that your full name? Mr. Allen, would you please raise your right hand? Mr. Allen, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Allen, you may put your hand down. State is represented in this case again by Attorney Erica Porter. And again, Ms. Porter, how are you doing? Okay, now, the probation officer in this case, would you please state your full name? Marva Carthon. How are you doing, Ms. Carthon? I'm doing fine. Thanks for asking. Now, Ms. Carthon, Herbert James sent over an administrative hearing, and in this administrative hearing, he requested that this case be set for judicial review before the expiration of Mr. Allen's probation, which is June 11th of 2024. Is that correct? Now, in this administrative hearing, the probation department states that the defendant, Mr. Allen, has not made no progress and does not appear to be motivated in doing what it takes to satisfy his court-ordered conditions. It further states that the defendant has not obtained employment, performed any hours of community service, and has only paid 83 hours toward his probation and court-order fees. And the defendant is approaching expiration on June 11th of 2024. And it further states that based on his performance, the community supervision officer does not foresee the defendant satisfying his court-ordered conditions by his scheduled expiration date. Is that correct? Okay. Now, Mr. Allen, I see that you were placed on probation on June 12th of 2023. Is that correct?
Sure.
Let's see. Pull up the judgment right quick. And in this motion, in this judgment rather, under your conditions, you were required to pay fine fees in the amount of $852. Your fine was $500. You were also required to reimburse Jefferson County Court-appointed attorney's fees, and your probation fee was $60 that you were required to pay each man a year, and that's a fee of $15 a month. I think you was also required to pay a reimbursement fee of $15. You also was required to perform 80 hours of community service. Now, I'm gonna go back to the date that you received probation, which was June 12th of 2023. Now, at that time, when the court told you what the fees was, the court also asked you whether or not you can pay the fees, and you stated that you could pay the fees.
That's why I have my job now that I've been looking for jobs, doing jobs. I have interviews tomorrow as well. Been like making sure that I'm trying to get it, so once I do, my first paycheck do go into these funds.
Okay, so basically you're unemployed at this time.
Yes,
How
sir.
long have you been unemployed?
I've been unemployed for about 3 months now.
3 months. Okay. The state, I thought you had raised your hand.
No, this was it.
Okay. Okay. Now, Miss, that Carpenter, what is the probation office recommending?
Well, at this time, based on his progress, I mean, I don't foresee him being able to complete it by expiration.
Okay,
I would think that Mr. Allen would need to let us know whether or not he's gonna be committed and doing, because it would take him to pay $440 a month in order to have that paid March through April.
okay.
Okay.
Okay, this is based on what I'm hearing, what the court is going to do. The court is going to convert his
Have I used my W-2s, my own my taxes to also help pay this all?
now, do you have
I have about like 4 W-2s, I'm just waiting on my.
four W-2s?
4 W-2s for my taxes, I'm waiting on the last two just so I can go ahead and do my taxes and be done with it. My taxes.
Yeah, well, I mean, we can do that, but I think we can also convert your fine and court costs to community service.
Mhm.
Apparently, if you're not working, you got time, so you have some time, you can serve the community and work off your fine and court costs. You already have 80 hours of community service that you're required to do. Apparently, you haven't did any 80 hours of community service. You told the court that you've been unemployed for 3 months. So you've had 3 months you had time.
Yeah, I was too focused trying to get a job because
Well,
that's my main thing. You know?
yeah, but I mean, you're saying you're focused to get a job
Mhm,
and actually working on the job are two different things.
mhm.
So you wasn't working all day trying to get a job. Okay,
I feel what you're saying, sir.
so what we're gonna do, let's see, what his judgment was his fine and court cost $552? I think it was $552. Must have been $500 plus $352 court cost. I'm looking at I'm looking at the judgment. So let's do this. That's 300. We can modify his probation. That's 852. That'll be an additional 68 hours of community service. Okay, so that's gonna reduce what you actually would have to pay back.
I'll take that.
Yeah, but you need to start,
How many
He-
hours was that, sir?
yeah, he has 68 plus the 180, yeah, 148.
But we're converting 68. How
We
much was
we're converting $852, that's fine and court costs, to 68 hours of community service. Okay, now. Because it seemed like most of his problem is fees. I guess he's been reporting because they don't say anything about him not reporting. And so it's fees and the community service. So right now, to take some pressure off of you, you need to start doing your community service.
That's right.
And your probation officer can provide you with locations that you can do your community service at. Okay.
Yes, Your Honor, I have done that. Referred him to places, but he hasn't went. I also referred him to the Texas workforce and instructed him to bring verification that he was registered, and also his job search logs, and when he comes, he don't.
Okay, this is what we're gonna do. We're gonna reset this case for 30 days. And we're gonna come back in 30 days. It's gonna be another review. It's gonna be a follow-up review. And at that point, it'll tell us whether or not you're serious about this probation.
That's right.
Because Because at that point, within 30 days, you should have a lot of your community service knocked out.
Yes, sir.
If you haven't did any, yeah, then you'll be sending a message to us that you don't want to do it and you don't want any progress.
Yes,
You don't want to make any progress.
yes.
Okay? So I'm signing this order. It's 6 to 8 hours, okay? 6 days. So we're gonna give you an opportunity, try to make up. This is the 21st. Or to catch up on your probation. Okay. Now, if obviously, if you don't do what you're required to do on your probation, the probation office can file a motion to revoke probation. And if they file a motion to revoke your probation, you can get up to 90 days in the Jefferson County Jail because your probation is 90 days probated for 1 year. Okay,
Yes, sir.
so the choice is yours.
Yes, sir.
All right. State, do you have anything else? And Ms. Carthen, you have anything else? Okay, well, Ms. Carthen, it's nice seeing you. And Mr. Allen, your case is gonna be reset 30 days. Don't give him no more than, that's 30 days. We don't want to give him more than 30 days. We're gonna give him exactly 30 days so we can, that'll be the first Friday after 30 days. On a Wednesday, excuse me, on Wednesday, that's right. Oh, that's today? Okay, that's good. Well, okay, this, all right, thank you.
Thank you.
You're welcome. Well, you're gonna stand in front of our court coordinator, get your reset. Once you get your reset, you're free to go and you have a blessed day. Yes, yeah. Ms. Carthen, you're gonna get a reset too. So you can, she's just giving it. That's for you. All right? That door is locked. You need to go through that other door. We'll see you in 30 days. That should be filed. Is that a file?
You know, we sent it downstairs now.
It's already filed?
It should be.
Okay. You can hang on to it and put it in your, and I'm gonna need a. Okay, plus we have that modification that he signed. I'm gonna need a copy of that. We'll need a copy of that for the next hearing. Okay. Oh. Next case is cause number M333310, case is style of state of Texas versus Jadarian O'Brien Taylor. Mr. Taylor is on Zoom. Mr. Taylor, you can take your mic off of Zoom, off of mute.
Yes, sir.
And Mr. Taylor, you're represented in your case by your attorney, Attorney Dustin Gallimore, who is also on Zoom. Mr. Taylor, how are you doing?
Doing well. How are you?
I'm doing fine. Thanks for asking. Mr. Gallimore, how are you doing?
I'm great, Judge. How are you today?
I'm doing fine. Thanks for asking. And the state, well, the probation officer in this case is Mr. Gary Gilliam. Mr. Gilliam, how are you doing? Yes. Now, let's see, Mr. Gallimore, this case is on the court's motion to revoke probation docket. What is your announcement? Oh, hold on a minute. Defendant must appear in person. I see here that the defendant was supposed to appear in person.
I
That was
believe that was the prior setting, Your Honor. The last time we were here, they were gonna look into whether the new offenses were filed.
Okay, Mr. Gilliam, not Mr. Gilliam, I was just informed that, or that I have a motion to dismiss the motion to revoke probation in Mr. Taylor's case. Is that correct?
Yes, sir.
Is that correct, State?
Yes, sir.
Okay. And Mr. Galmore,
Yes.
I'm signing the motion to dismiss the motion to revoke probation in Mr. Taylor's case. And Mr. Taylor, I've just signed the motion to dismiss the motion to remove probation in your case. Mr. Gilliam, does he have any more time left on probation?
No, sir.
Okay, so his probation has expired?
Yes, sir.
Okay, so Mr. Taylor, I've just signed this motion to dismiss the motion to revoke probation. And at this point, you are no longer on probation. Congratulations. It states that you have paid all your fees and you were, everything that you were required to do on probation, you've done it. And so congratulations.
Yes, sir, Your Honor.
Okay, now stay in contact with your attorney. I've just signed this motion to dismiss. You're free to go and you have a blessed day. And Mr. Galmore, you're free to go as well and you have a blessed day.
Thank you, Judge. You too. Bye-bye.
Yes, sir. Thanks a lot.
You're welcome. Oh, let's have some more. Next case is cause number 23 CCCR 1248. Case of style of State of Texas versus Bryslin Denisha Johnson. Come forward. Ms. Johnson, your full name is Bryslin Denisha Johnson? Denisha? Okay, how you doing, Ms. Johnson? I'm doing fine, thanks for asking. And Mr. Kimler, what is your announcement in Ms. Johnson's case?
I'll try, Your Honor. I think the victims attempted to do a non-prosecution affidavit. The alleged victims.
Okay, so
What type of case is this, Your Honor?
this is on the announcement docket, Bryslin Johnson?
Okay, but, Mr. Gilliam was borrowing my docket, but if I recall correctly, I thought this was a possession case.
This is possession of dangerous drug.
Gonna take responsibility.
Okay.
He called the investigator yesterday.
Okay, well. State, so what's your announcement?
Trial.
Reset it for trial, okay. Okay, good. But April 8th, this case will be reset for April 8th on 2024. Ms. Johnson, your attorney's gonna get you reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. Next case is cause number 23 CCCR 2136, case of style of State of Texas versus Fred Toops. Mr. Toops, how are you doing? I'm doing fine, thanks for asking. Your full name is Fred Toops? Fred Allen Toops? Mr. Toops, you're represented by your attorney, Attorney Ralph Kimler, Attorney Kimler. What is your announcement in Mr. Toops' case?
Trial.
Okay, give us a reset. Is it April 8th? Mr. Toops, this case will be reset for trial April 8th, 2024. Attorney gonna get your reset. Once you get your research, you're free to go and you have a blessed day. Go ahead, be ready, yeah.
Yeah, just got. No, right. Those are yours. All of them. No, no, that's not other people.
I get on live.
You know, okay.
Jefferson County Court, Law number 2 is back in session. The court is in session and calls number 23 CCCR 0026. Case is styled the state of Texas versus Mark D. Love. Mr. Love, would you please come forward? All right, how you doing?
Doing good.
Mr. Love, your full name is Mark D. Love.
Yes, sir.
How are you doing, Mr. Love?
Doing good.
That's good. Mr. Love, I have before me, well, Mr. Love, you're represented in your case by your attorney, Charles Rojas. Attorney Rojas, how are you doing?
Doing well, Judge, thank you.
And Mr. Rojas, do you waive a record in Mr. Love's case?
We do.
Mr. Love, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Mark D. Love, on or about January 6th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Love, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Love, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Mr. Love, I also have before me, Mr. Love, did I swear you in?
No.
Okay, Mr. Love, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. Now, Mr. Love, I'm going over this again. Mr. Love, I have before me a document that is titled information. In this information, it alleges that you, Mark D. Love, on or about January 6th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Love, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Love, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
So, Love, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes.
On page 2 of the same document, there are a set of initials, ML, on a line next to a box that says check guilty. Did you place your initials on this document?
I did, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant?
It is.
At the top of this document, there are 2 boxes checked. The first box that's checked states that there's a plea, that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Love, before you sign and initial these documents, did your attorney go over these documents with you?
Yes. You did.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
It is.
Mr. Love, are you a citizen of the United States? State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 into evidence?
Yes, Your Honor.
Any objections?
No objection.
No objection. State's Exhibit number 1 will be admitted. Mr. Rojas, you have advised and counseled Mr. Love. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Love, your attorney, Mr. Rojas, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes,
Mr. Love, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement in this case?
We do, Your Honor.
And what is that agreement?
In exchange for the defendant's plea of guilty of no contest, the state is offered 180 days over 1 year probation, $500 fine, 60 hours community service, and court costs.
What is this, court cost?
277.
277. He was appointed. Okay. Let's see. Okay. Mr. Laws, the state is offering that you serve 180 days in the Jefferson County Jail. However, you would not be required to serve any time in the Jefferson County Jail on this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you will be required to pay a fine of $500 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month. You will also be required to pay a reimbursement fee of $15, and you'll be required to pay reimburse Jefferson County for the court-appointed attorney's fees of $250. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $177 a month. Will you be able to pay the $177 each month?
Yes, sir.
Okay. You will also be required to perform 60 hours of community service and adhere to the other standard terms and conditions of this probation. Now, Mr. Love, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. Love, I'll follow the plea bargaining agreement that you've entered into with the state. Mr. Love, this will conclude your case. You're going to stand next to your attorney, follow the directions of our court coordinator. Once you finish following her directions, you'll be free to go, and you have a blessed day. And Mr. Rojas, I think this is your last case. You're free to go as well, and you have a blessed day.
Thank you, Your Honor.
Okay. And okay, let me do this.
You put up a cash loan?
Mr. Love.
Yeah, I have a bond.
Okay.
Yeah.
So they were just kind of do your fingerprint, and you need to straight to probation.
They don't know this.
I don't know, you
I'll
have to contact their office and let them know what happened today.
You have that, those deferred orders of dismissal. You had a deferred order of dismissal on Montgomery.
Yes, sure. Yes, sir.
The court is in session in two cases. First case is cause number M327-826. Second case is cause number M328-714. Both cases are styled the state of Texas versus Q.J. Montgomery. Mr. Montgomery, is that your full name? Mr. Montgomery, would you please raise your right hand? Mr. Montgomery, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Montgomery, you may put your hand down. Mr. Montgomery, your probation officer in this case is Ms. Denise Hunter.
Yes.
Ms. Hunter, how are you doing?
I'm great. How are you doing?
I'm doing fine. Thanks for asking. Hold on a minute. Okay, now, Mr. Montgomery, I have before me two deferred adjudication orders of dismissal that was filed by your probation officer, Ms. Hunter, and his motion basically states that on September 27th of 2021, you were placed on, you were placed on deferred adjudicated probation for the offenses of assault, family violence, and evading arrest detention. And your probation at that time was 2 years deferred adjudicated probation in each case. And in this motion, it further states that you were granted a 1-year extension to this probation. Is that correct?
Yes.
Okay, so that will put his, let me see, it's 2023. So that'll put his expiration date at September 26th of 2024. Is that correct? You got a year?
Correct.
Okay. Now, in this motion, Ms. Hunter states that you have satisfactorily served 1/3 of your assessed time and has not been involved in any criminal offenses during the said probationary term. And it also states that the defendant was granted an extension to allow him more time to pay off his financial obligations as of the day he has paid in full. Okay, is that correct?
Yes, sir.
And so, Ms. Hunter, you are asking that he be released off of probation. Is that correct?
Yes.
And state, what is your recommendations?
The state has no objections to the dismissal of deferred adjudication in these cases concerning the fact that the defendant has completed the conditions of probation.
Okay, and just a little bit more information. Ms. Hunter, could you just tell us how he did on probation overall?
Mr. Montgomery works full-time. He makes payments. He was behind on his payments. So we did request an extension in order to allow him more time to pay. He has paid in full as of January 24, 2024. He was drug tested regularly. He hasn't tested positive for any illegal substances. He completed community service and all other conditions of probation. No violations that we know of. So we requested to allow him to successfully complete probation.
Okay, now, Mr. Montgomery, the court is going to grant this motion. The court is going to sign this motion, adjudication order of dismissal. Now, hold on, wait up. Hold on, I think I saw something in this file. Want to make sure that. Okay, what I was just confirming, at one time he had a motion to revoke probation, but that was dismissed. Is that correct? Okay. So the court is going to grant this motion, this deferred adjudication order dismissal. And what that means is, Mr. Montgomery, you're no longer on probation, and congratulations for successfully completing your probation. And I would like to encourage you to continue to use some of the things, some of the tools that you learned or that you acquired while you were on probation. Okay, it would serve you well in life. Again, congratulations for being serious about your probation, and congratulations for successfully completing the probation. Now, I usually give people handshakes. Well, in our circumstances, we don't do that. However, I'm gonna give you an air handshake. Okay? All right. Now, you're free to go. And you have a blessed day. You have a question?
Yeah, possible to get like, paperwork showing up the dismissal, so I can know.
Oh, yeah, we could give him a copy of it.
And if it's for
Okay. Ms. Araji usually get excuses for work.
Yes.
Okay. What you will have to do once you leave this courtroom, soon as you walk out the courtroom, turn to your left. Well, turn to your left. There's some blue doors, right? Immediately, well, it's next to the courtroom. Open the blue doors, walk down the hall. There's a lady behind the window, glass window, and she can give you the excuse that you need for work. Okay, but we will give you a copy of your dismissals. So just have a seat in that first chair on the wall, and when the court coordinator is ready for you, she can ask you to come up. She can give you the dismissal. Once you get the dismissals, you're free to go, and you have a blessed day. And Ms. Hunter, nice meeting you. You're free to go, and you have a blessed day.
Thank you, sir.
Thank you.
Thank you, Ms. Hunt.
See you now. Okay, who else? We have This is cause number 23CCCV 0492, case is styled the state of Texas. Well, the case is styled in the matter of Taisha Recall Bowman. Is that your full name?
Yes, sir.
How you doing, Ms. Bowman?
I'm good.
That's good. Now, Ms. Bowman, would you please raise your right hand? Ms. Bowman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Bowman, you may put your hand down. Ms. Bowman, I have before me a petition for order of non-disclosure under section 411.075. Now, in this motion that was filed by you, it states that you were previously charged with the misdemeanor offense of evading arrest, detention, in cause number, in the criminal cause number 294338 in this court. Is that correct? Okay. Now, this petition, looking at your petition that you filed, it further states that you were placed on deferred adjudicated probation or community supervision. Is that correct? You was placed on deferred probation for this case?
Good.
Okay, well, I have a copy of I have a copy that's attached to your motion. That's attached to your petition. It says deferred adjudication order. And it was entered on October 2nd of 2012 for the offense of evading arrest. And you were placed on deferred adjudicated probation for a period of 1 year beginning on October 2nd of 2012. I also have a deferred adjudication order dismissal, which basically states that you completed the deferred probation and you were released because you satisfactorily served 1/3 of the assessed term. And the date of this order of deferred adjudication order of dismissal is April 30th of 2020, April 30th of 2013, which is also attached to your petition. Okay? Now, and in your petition, it states that you have, the petitioner has been previously convicted of or placed on deferred adjudication for an offense other than a traffic offense punishable by a fine. It further states that you received a discharge or dismissal. Prior to September 1st of 2017, which makes you eligible under section 411.0725. And that's the section or the article that you cited in your motion. Now, it says also that finally petitioner satisfies requirements of 411.0725 in that the petitioner has waited the requisite time as indicated below. They say on or after the discharge or dismissal. So pursuant to order section 411.0725, you became actually immediately eligible for this non-disclosure. Under subsection CSL, a person may petition the court that placed a person on deferred adjudication community supervision for an order of non-disclosure of criminal history record information under this section only on or after 1, the discharge or dismissal, if the offense for which the person was placed on deferred adjudication was a misdemeanor other than a misdemeanor described by subsection 2. So you were placed on deferred probation after this time period, and so therefore you were immediately eligible. As indicated in your petition, and it states that you satisfy the requirements of section 411.074, which means you have not been convicted of any one of these other offenses that's listed under this article. Is that correct? Correct. Now, it also states that now it also states that you're eligible because you're not eligible under section or article 411.072 of the government code, and that you have received your discharge, you waited the requisite time, you met the requirements of 411.074, you were placed on deferred education for a qualifying misdemeanor, and you met the government code. The other thing is, it states in this, I guess the court will, let's see if it's here. Oh, here it is. Now, could you state to the court why it would be in the best interest of justice that you be granted this non-disclosure?
A better job opportunity.
For better job opportunities? Okay, so this has interfered with your ability to obtain employment?
Correct.
Okay. State, do you have any comments or any objections?
The only comments and objections that the state would make is looking at Miss Bowman's history. There were later cases in which she was either convicted or placed on deferred probation. Just given those facts, I would be concerned about removing this from her history.
Okay, let me see. Okay. So the concern that the state has is that you're saying that after she had completed her deferred adjudicated probation, she had some convictions. Is that correct?
one conviction and one placement on deferred probation in this county, Judge.
Oh, okay. And I'm looking at the provision, it says, except as provided by section 411.074, a person may petition the court for an order of non-disclosure under this section, regardless of whether the person has been previously convicted of or placed on deferred adjudication, community supervision for another offense. So when it says previously convicted, are we saying prior to her being placed on this, prior to her being placed on deferred adjudication in this case, or prior to her requesting the non-disclosure? So I think that may be an issue we have to, I may have to look up, may have to research that issue. So what the court can do at this time is take this case under advisement and research that issue. It talks about a previous case. If you had previous conviction, you're eligible. So the question is, what does the statute mean when it says previous convictions? Okay, is it previous convictions prior to you being placed on deferred adjudication for this case, for this case, or prior to you requesting the non-disclosure? State?
And the state would argue that that verbiage is regarding prior to her placement on deferred probation.
Okay.
So the subsequent conviction and subsequent deferred probation for other cases would make her ineligible for non-disclosure in this case.
You say it would make her ineligible?
Yeah, that's what the state's arguing.
Okay, so what the court is gonna do at this time, the court is not gonna grant it at this time, the court is going to take this matter under advisement. And what that means is the court is going to do some further research on that issue, okay?
It means that I can get a felony, a non-disclosure on a felony, but not a misdemeanor?
I'm not saying that. I'm just saying that we need to see what the law is in this case. Now, your situation under the felony may be a little different from your situation here. I don't know. We don't know what your situation was. I'm just saying under these circumstances that we have before us, the court is going to research it. And then once the court researches it, then the court will give you an answer. Okay? But at this moment, we'll just take the matter under advisement. That's what we mean. When we say we take the matter under advisement, we're going to research it.
And then be reset.
And then we'll reset and let you know you can come back in. Okay? All right. All right. Let's we might want to give her Miss Bowman. Don't leave. We're going to give you a reset date so you can come back. So just have a seat. Yes, you can have a seat in that first chair. Okay, we'll give her a reset date. We'll have a record report.
You want a court report?
Yeah, we have one now.
No, we talk about when we do the research. She's not.
Yeah, because we all of this is still gonna be on the record.
Oh. So.
Just find out a date. We'll give you a date, okay?
Oh, Miss Davis right here.
Miss, Lord, this is cause number 23CCCV 0614, Casey Style, State of Texas versus Deja Brown. Ms. Brown, is that your full name?
Yes.
Ms. Brown, would you please raise your right hand? Ms. Brown, do you swear firmly to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Brown, you may put your hand down. How are you doing, Ms. Brown?
I'm fine.
I'm doing fine. Thanks for asking. Now, Ms. Brown, I have a petition for order of non-disclosure under section 411.75, 411.0725. Now, before we go any further, I was looking at your petition, and when I reviewed your petition, there were some things that was missing. All right. I have a little arrow here, the blue arrow, and it says, and I'm gonna just read the sentence that arrow is pointing at the blank line. It says the period of deferred adjudication started on. You're supposed to put a date in there, and you have it is blank right here.
Yes, sir.
Supposed to be the date that your probation started. Okay, and then it says a copy of the judgment or order placing defendant on deferred adjudication probation is attached. And when I looked at your petition, they did not have a judgment attached. What was attached was a dismissal in another case. The judgment is your order of probation that you receive. You can probably get a copy of it in the
Clerk's office
in the county clerk's office downstairs.
Okay.
Okay. And so let's see. Let's see what else we had. The deferred adjudication order dismissal that was attached. Hold on a minute. Okay. That's the only thing that I see. Actually, yeah. Actually, Mr. Hubel, I just noticed something. Now, I stated she didn't have the date printed here,
Is it located
but
somewhere?
it's located in the deferred adjudication order of dismissal. It says on the 30th day of November 2020, this case was called to trial and the defendant entered a plea of guilty and nolo contendere to the court for the offense of assault, bodily injury. The court found beyond a reasonable doubt that the evidence supported the finding of guilt. At the request of the defendant under Article 42A of the Texas Code of Criminal Procedure, adjudication of guilt was deferred and the defendant was placed on community supervision for a period of 6 months, subject to the terms and conditions listed on the community supervision. So actually, the date that should be here,
Yes, sir.
the blank, is already listed here.
Okay.
Okay, so we can, I guess we just do incorporation by reference. I think that would be the term that's normally used. It's referred to here, so it's actually incorporated by reference. So now we still don't have a copy of the deferred adjudication order. The order. You can get that from downstairs. Now what you can do is amend your petition. And when you amend, you're just gonna write the word amend on here, and everything else gonna stay the same. You're gonna fill in the blanks that needs to be filled in. You're gonna attach your whatever else need to be attached. And then I think we'll be ready to look at this document to see whether or not it meets the eligibility requirements of Article 411.0725. Okay? Now, and the reason why we're telling you that is because anytime that you represent yourself, you are your own lawyer, your own attorney.
Yes.
Okay? And so we basically hold you to the same standards as we would hold an attorney to. Okay, so but the things that needs to be fixed or corrected are kind of simple.
Okay.
And so you should be able to do those things. And then once we do that, then we'll be able to take a hard, tough look at this here. Petition to make sure that you meet the eligibility requirements. State, you have anything else?
Nothing from the state, Your Honor.
Okay. So what we're gonna do, we're gonna reset your case and give you opportunity to make those corrections that you need to make. This file, I think that, oh, your file is actually in the in the county clerk's office.
Do you want me to tell them?
It's on here. It's 325522. That was a cause number for your for the misdemeanor case, the assault case,
That'll be what you asked for. Yes.
to get your judgment right. I think that's it, isn't it? Oh, she went through somebody else? Somebody did this for you? She said somebody easy expunction?
Easy expunction?
No, I did it myself.
Must have been from somebody, that must have been on somebody else. Okay,
So just to clarify, I need the order for.
the deferred adjudication order is the order that placed you on probation.
Okay. And then. said
Now you had
something
that, he
about-
gave you that number?
Yes.
Right, in that deferred adjudication order, you're gonna see the date you was placed on probation.
And I need to fill that.
That would need, but actually, you already have it here on this here. What is this? Deferred adjudication order dismissal. The date is right here. Yeah, so you just have to write it in.
So it's just those two things, the order,
That's,
fill in the date.
yeah, you saw anything else?
No, Your Honor.
Okay.
Yeah.
Just wanted to clarify.
Okay,
You need something to write on? Thank you.
okay. Oh, she's gonna need the cause number for the civil case, this 23CCCV 0614, because that's what needs to be corrected.
Okay.
Yeah, that's what needs to be corrected. This petition,
Yes, sir.
that has a different cause number from the cause number that you, from your criminal case. Okay.
Give the packet back to me and I'll fill it out, attach it, and then give it back. Is that how you amend it? Is that how I would amend it?
Or they can give you a copy of it.
And I can turn it in.
I would think, because you, other than that, you'd have to have the this paperwork. You know what? Yeah, you might have to. Yeah, but I'm just thinking, it may not be as simple as, is there, no, it's nothing sworn on here. I thought he might have had something like an affidavit or something. Okay, yeah.
I did have to get it noted.
Your Honor, this.
I think what you got notarized was the,
Oh, yeah.
your petition for a pauper's affidavit and saying that, you didn't have to pay.
Yes.
Right.
Your 23 CCC.
CCV,
Okay, CCV.
yeah, because it's,
And then 0614.
0614, yeah.
Oh,
That's the civil case. Okay, they're gonna just have a seat in that chair. They'll give you a reset. You have a blessed day. Oh, she has